Dear students, welcome to the lecture session on the topic Appeals, Reference and Revision. In our previous classes, we have already learned about the basic concepts of CRPC, bail, arrest, bail bond, pre-trial proceeding, trial proceeding, judgment, etc. Today we shall gain idea about appeals, reference and revision. Let us begin with the term appeal. Appeal means any proceeding taken to rectify an erroneous decision of a court by bringing it before a higher court. The person who files an appeal is called an appellant. Under the Code of Criminal Procedure, the term appeal has not been defined, but the provisions are provided under Chapter 29 from Section 372 to 394 of the Code of Criminal Procedure. Again, according to the Black's Law Dictionary, an appeal means a complaint to a superior court of an injustice done or error committed by inferior one whose judgment or decision the court above is called upon to correct or reverse. Now, what is the scope of appeal? Well, to answer this, I would let you know that Chapter 29 containing Section 372 to 394 lays down the legal provisions related to the appeals. So, the main objective of keeping this chapter or sections is to correct the errors. So, appeal acts as a corrective device. Now, let us know about the sections of appeals. First comes Section 372. According to Section 372, no appeal shall lie from any judgment or order of a criminal court, except as provided for by this code or by any other law for the time being in force. So, from this section, it is clear that if a person wants to file an appeal, then it must have a sanction by the Code of Criminal Procedure or by any other law. For example, if a person has filed a case against another person and the judgment has come in favor of another person, then if the person filing the case is not satisfied and finds that there is an error, then he can file a case before the higher court if the code or the law or the statute through which he has filed the case permits him to file an appeal. So, in this regard, if we think about the term appeal, then we can classify appeal into two parts. The first part says about no appeal in certain cases, and the second part tells about appeal in certain cases. Coming to the first part, no appeal in certain cases. So, in which cases appeal can't be filed? Number 1. In cases in which the accused pleads guilty. According to Section 375 of the Code of Criminal Procedure, if any accused pleads guilty before the court, then no appeal lies in those cases. Next comes if any petty case comes before the High Court or the Sessions Judge or the Metropolitan Court or any magistrate, Then if it is a petty case, then no appeal lies in such cases. So where we can find this provision? Under section 376 of the CRPC, we can find this section. So till now it is clear, I hope. If you have any query, let me know. So we can shift to the next portion. Next portion says about appeals in certain cases. So in which cases we can file appeal? It is also provided under the CRPC. The first one says that appeal in cases of acquittal. Suppose a person is being acquitted by the court. Then, according to section 378, the state government may direct the public prosecutor to present an appeal to the High Court from any original or appellate order of acquittal passed by any court other than the High Court, or from an order of acquittal passed by a court of session in revision. That means, if suppose Mr. X is a victim and Mr. Y is the person doing the wrong, if there is no evidence or there is insufficient evidence, and due to that Mr. Y is being acquitted, then if the state government wants, then through public prosecutor they can file an appeal before the higher court, that is the High Court, in case of a case which is previously being filed in the court of session. Then they can file a case before the court of higher authority, as for example High Court, and then if they have sufficient proof, they can go with that and appeal. So if there is any case of acquittal, there is a chance of appeal. Next comes special right to appeal. Suppose one person or more than one person are convicted in one trial. Then if the judgment or order which is passed is appealable in nature, then they can have the right to appeal. This is called special right to appeal. And where you can find this provision? Under section 380 of the CRPC, you can find this provision. Next topic which we will focus is reference. So what is reference? Reference is explained under chapter 30 of the Code of CRPC and section 395 and 396 deals with the reference. So what is reference? Reference means the decision of a question by a referee. A question referred to a referee for his decision or opinion. Suppose there is a question which needs to be answered. So a person has filed a reference case before the authority to answer that question. So if we see section 395 and 396, then we can know about the term reference. Reference denotes reference to the High Court. So for referring something, you have to ask a question of law before the court, that is the High Court. So what section 395 provides? Section 395 says that where any court is satisfied that a case pending before it involves a question as to the validity of any act, ordinance or regulation or of any provision contained in an act, of opinion that such act, ordinance, regulation or provision is invalid or inoperative, then they can raise a question before the higher court to provide an opinion on that regard. Suppose there is a case and validity of certain section of act is in question, then they can refer it before the higher court, that is the high court, to get the answer whether that provision is valid or invalid. Whereas section 396 provides about the disposal of cases, and it says that when a question has been referred, the high court shall pass such order thereon as it thinks fit, and shall cause a copy of such order to be sent to the court by which the reference has been made, which shall dispose of the case comfortably. That means when a reference case is being filed before the higher court, that is the high court will provide a order, and that order should be passed on before the court who has asked the question. So till now, if it is clear, we will move before the provision 1 of revision. So now let's us know about the term revision. So what is revision? Revision means simply revising something, and under CRPC section 397 to 401 is regarding revision. There are 3 sources of the revisional jurisdiction acquired to the higher court. Number 1, section 397 to 401 of the CRPC. Number 2, article 227 of the Constitution of India. And number 3, the power to issue the writ of certiorari. So already you have gathered information about the constitutional portion. Now we will know about the criminal revision portion, that is from section 397 to 401. Section 397 empowers the High Court for calling the records for exercising the power of revision from the inferior court. So if he wants to revise something, he has the authority to ask the inferior court to provide some documents or records to the High Court. Suppose in your exam you have got a certain percentage, you are not satisfied, you want to revise. So when you file a review petition or a review form fill up is done, then the copy is being reviewed. Likewise, if a revision petition is being filed, the higher court will revise the orders, judgments passed by the inferior court. That means the superior court will revise the judgment orders passed by the inferior courts. Next, what are the powers of court of revision to order inquiry? This is provided under section 398. It says that the High Court or the Sessions Judge, after examining any order, may direct the Chief Judicial Magistrate by himself or by any of the magistrate subordinate to him to make further inquiry. Likewise, Section 399 and 400 also deals with certain provisions. Next comes the High Court's power of revision, which is provided under Section 401. Section 401 says that High Court has this revision power and it can apply in three ways. Number one, in suo motu way, that is in its own motion. Number two, if an application for revision is being made by the aggrieved party, then the High Court may revise. And the third says that any third person who is directly affected by the decision of the lower court files a revision case, then the High Court may revise the things. So till this is all about the provisions of appeals, reference and revision. In the next lecture, we shall know about the distinction between reference and revision, distinction between revision and appeal, and distinction between reference and appeal. So if you have any query, let me know. Till then, have a safe stay at home. Take care.